open that page, I'll search for my fix, find what I need in the deep dark abyss.
Hello and welcome to another episode of AI Skeptics. We're really excited today to have Deidre Cunningham and Sarah Hudson with us, who are both defense lawyers. Jake, how did we meet these beautiful women here?
These women wrote to us, having listened to the podcast, I believe. Some of our organic traffic. So yeah, you're part of AI Skeptics Nation already. And they wrote in saying, hey, their members are dealing with these issues on the front lines. And might we have some information for them? So I'll let them take it from here, but we were just thrilled to know that, this podcast might be of use to actual lawyers out there practicing on the front lines. So please tell us who those lawyers are and what they're grappling with. Thanks for being here.
Awesome. Thanks for having us. So like you said, I'm Deidre Cunningham. I work at the Washington Defender Association. We are a statewide member nonprofit. We have over 1,900 members who provide legal representation to people at public expense. They work in criminal and civil proceedings. They represent children, youth, and adults throughout our whole state. We have 39 counties, and we don't have a statewide office. Let's just say we're a decentralized public defense system. And so our nonprofit really provides legal education and support to those attorneys. We also do public policy work on their behalf in our state legislature and with our state Supreme Court. And how did I listened to your podcast, and I thought
that is so exciting, actually.
Yeah, it was great. It was actually, I think I told you, it was in a legal bulletin from one of our local law librarians. And it was such a great podcast. And I was glad to find it. But it was interesting because Sarah and I, who I'll let introduce herself, had started training on AI with our members, and it fascinated me. So I'll stop there and let Sarah introduce herself.
Hi, I'm Sarah Hudson, and I actually heard about this because Deidre called me very, very excited. She was like, you have to talk to me about this. I found this podcast. You have to listen to it. So I do indeed now listen while I'm walking my gigantic dog, which is super fun, but that's about the only time I have in a day. I also work for Washington Defender Association. I do things that are a little bit different than Deidre. I work in the post-conviction space. So I work with people who've been convicted and have been convicted usually in a manner that was not in adherence with their constitutional rights, typically their Sixth Amendment right to counsel. And those people also happen to be non-citizens. So like every single group of people who may or may not be politically disfavored is kind of who I work with on a daily basis and try to help those people stay with us in the United States and stay in their communities and families. So we have a varied background. So
yeah. And fascinating too. I mean, one of the things we decided to do in this initial conversation with you guys is just to devote a few minutes at the beginning, one of the topics, in fact, on like what you guys do and how AI even comes up in your work, because, you know, we want to be helpful to you, and we're going to address a couple of the questions you have about from our perspective, how to think about stuff. But I would like to start with like, how does it come up in your work, with your clients?
Right. So I didn't even say what I do as a staff member, but what I do now is I support parents who are in prison and jail stay connected with their children while they're incarcerated. Our project's called the Incarcerated Parents Project. What I end up doing is working with their attorneys, themselves, their loved ones, anyone who's touching their case and is trying to help them either get their visits, or change orders that might be interfering with them getting visits. And I would say that part of our work, Sarah's more hands-on than in my role, but part of our work at our nonprofit is to give case support to attorneys and like community advocates who are working with folks who maybe no longer have attorneys. And that case support can look really different, but generally we're trying to find expertise or refer people to experts, trying to find them lawyer referrals and community, especially if their case is already over, so after sentencing. And so we basically are meeting people after they've been through the system, and someone is going to review what happened to them. Or we're supporting their lawyers who are still representing them on appeal. We do amicus work in that way. And occasionally we are lucky enough to have followed them from the beginning of their case all the way through, but that doesn't always happen, if that makes sense. So like trial attorneys will also reach out, but we can be contacted at any point. And a lot of our roles as staff attorneys is we're getting contacted directly from people in prison or jail who've got questions or need referrals or need support in some way.
Mm-hmm. Mm-hmm. Yeah. And Deidre,
So
how does AI? Oh, sorry. Go ahead, Jake.
It sounds like you're really picking up cases where it's like they might be falling through the cracks. There's already been a decision. Now they're trying to appeal. Like it sounds like these are that you're filling in these gaps between where people have representation, they have support, versus now they're in a moment where like they're in prison, but they don't have anybody having their back. And that's where you all come in.
Well, it's usually we're getting contacted at any stage, but I'll try and connect back to your original question, Kathy, about how's AI connected. It can come up at any point or in any way. And let me be specific about that. So sometimes AI is showing up in the initial defense of the case. Maybe there's discovery that's been provided by the state and those are records that the state is intending to use at trial, presumably, that may have been affected or changed by AI. It kind of depends on what people receive. We also get questions because we don't have a statewide system. We have a lot of solo practitioners, people in small legal law firms trying to provide representation. They have questions about how to make their jobs easier, how to be more efficient, how to be able to adequately represent people who are being charged by a government that has more resources than maybe their attorney does, right? And it can also show up, quite frankly, in how we're training folks. For example, like we do an annual training on ethics, and so we do try to keep up with the latest challenges. And AI presents a lot of challenges on an ethical level. I think Sarah and I decided on our own to try and train some basics of computer-based tools that claim to be artificial intelligence. Like, what does it mean? Where does this show up in your practice? Should you even be using these tools and things like that? Just because it comes in so many ways, both as an office manager, as a person trying to manage records in a case, and also in trying to defend people where someone's trying to use it as evidence against them in court. Yeah. Wow.
So, I mean, I'm thinking like about a bunch of cases where the judge was like, wait, or somebody was like, hey, wait a second, you just, the citations in your defense refer to law articles that don't exist, or they misquote law articles because they were generated by AI and like not checked before they were sent to the court. That's one, I presume that's one way you're talking about. Like,
yes, we have been training people not to do that.
Yeah.
And reminding them you have to verify all the citations. And also one that's overlooked that Sarah and I trained on, you have to present the opposite holdings. You have to find the case law that doesn't help you and present that as well, which I'm not sure the tools are very good at doing, to be honest. But yeah.
Is that a general rule of lawyering? I'm not a lawyer.
Yes, candor is it's one of the ethics rules. And so you not only have to verify that they're real citations, you do have to present, if there's a case that hurts your argument, you have to tell the court that, even if the other side didn't brief it. So,
wow.
Yeah. Yeah. Sorry.
How about you, Sarah? Do you have other examples of the ways that you interact or your clients do with AI?
So most of my clients actually have been caught up in the immigration system, which uses a ton of AI. I mean, when we talk about, okay, I'm going to do AI in air quotes because there's all different versions of what that is.
We do too.
But we're talking things like,
Sarah, that's part of it.
But we're talking about things like flock cameras that are tracking people and doing license plate reading so they can track non-citizens, or they can track people who are involved with non-citizens. And so we know that the government uses that sort of data. They have access to it. Why wouldn't they use it? But I'm sure there are algorithms in immigration court that allow, or you plug in factors and they say this person should be released, this person shouldn't be released, because AI does lots of fun things now, like checklists that allow you to be like, oh, this person has a criminal record. Tell me what that is. Okay, do this, do that, do this. And that's efficient, kind of. I mean, we all know that the court system is really about efficiency. They're looking to move people efficiently through the system, even if that means messing with people's rights. But, side note on people's rights. But moving people efficiently requires a process, and a process that can be automated. And so many times I find my clients have already interacted with these systems, but didn't actually know that they were interacting with them. And we have tried to train lawyers about that too, because it's not just our clients, but it is also the attorneys, because many people don't realize how much AI is baked into things without them even knowing about it. And so when you put things in, you have to know what you're doing and where you're putting it. I mean, I personally use AI. I'm probably the least AI skeptical here, but I also know what I'm putting into it and how I'm putting it into it. And I know where I need to verify because I know enough about it to say, okay, this isn't valid. I need to figure out where this is real and where this isn't, and where it's useful and where it isn't, because Deidre used to be a one-person show. I am definitely a one-person show. And we need efficiencies just like any other lawyers. But how you get to those efficiencies and the shortcuts you take is important. Yeah. And so that's how I find AI interacts not only with my clients, but my process. And I imagine people who have much busier practices than me, because I can tell you, I'd have I have a lot of clients, but I'm supposed to have 25 to 30. Because that is a good caseload for, let's say, a year. But many attorneys carry 200. Mm-hmm. And so trying to bake in those efficiencies just so you can give people the time that they deserve, instead of doing that, using that time doing paperwork, using that time updating your records.
Right. Okay. Yeah. Well, that's a really good place to start. I will just say that I couldn't agree more with you. That you want to make it work for you because you're overwhelmed with the amount of work you're doing, but also you have to understand its limitations. And by the way, Sarah, we use AI. We use AI. Yeah. When we say skeptics, it's not because we're skeptical that it's useful. The question is is it foolproof? And the answer is definitely no. But Jake, what were the questions that we wanted to answer?
Yeah, I'm going to dig into I'll read out the first question. And it goes right to what you were talking about. How do you know whether to trust it in this case? So, question from your members was understanding bias in the data. There's an old adage when discussing computer-based tools, GIGO, garbage in, garbage out. When systems actors are committed to using computer-based tools created from large volumes of unscrutinized data, where should a public defender start when critiquing its use or when attempting to educate decision makers who want to rely on that tool? So, this made me think actually to the air quotes around AI, this made me think to some examples that are pre-AI, pre the current generation of AI, but that are completely on point to this question. The first one that came to mind is the Compass recidivism risk score algorithm, right? Which I think ProPublica investigated years ago and found that Black inmates were judged routinely to have higher risk of recidivism because this algorithm, which was a sort of very basic scorecard approach to saying what's the chance that this person is going to reoffend, as we consider their, I think, parole application, and it relied on historical data on who was arrested and how often and how much. But taking a step back, we know that arrests are not a true measure of crime or criminality, right? They're measures of policing arrests. So so the algorithm learned that Black offenders were more likely to reoffend, but what they really meant was they're more likely to be rearrested. And the result is an algorithm that penalizes Black offenders or keeps them from getting paroled on account of their scores here.
Jake, I'm sorry to interrupt you, but I actually know so much about this algorithm. And let me just say, it was not even trained on convictions. It was trained on arrests. As I understand it, it was like literally who's going to be rearrested. That was the target of the algorithm, which makes it even worse in the sense that it's like basically trying to predict police activity rather than trying to predict crime. And it didn't really care if there was a conviction involved. And it had all sorts of questions that were very, I would say, and I'm so glad to finally talk to you guys about this, because I was like, I always want to talk to a defense attorney about this, because it seemed to me that I'm not sure if it was this one, but there was another recidivism risk algorithm that was literally asking, was anybody in your family in prison? Like, it's like, how is that constitutional? That's not what we do in this country. It was going to raise your score if you said yes. Like, it asked you, do you have mental health? I think this was the LSAR or some other recidivism, not the Compass one. But basically the point is that the questionnaire that you fill out at the beginning was asking all sorts of proxies for base poverty and living in a highly policed neighborhood. And the prediction target was rearrest. It's just one example. Jake, I didn't mean to interrupt you, but it's so bad. It's just, and it seems so unconstitutional.
And the target was rearrest, police behavior, but it was used to suggest reoffense.
Yes.
Which is not what it was testing at all, right? Or reporting back at all. Yeah.
Well, and that's I would say,
common.
Sorry, Deirdre, go ahead.
No, I was going to say just in the return to prison rates, it's pretty common that they use arrest data, and they also use warrant data that isn't correlated to release. We had a recent report from our state policy organization, and I had to call and ask them, what is this return to prison? What was the data? And they were relying on warrants being issued, and it didn't matter if the crime for which the warrant was issued was before they went to prison. So no new offense, right? Just that a warrant had issued. And it also didn't matter if the person actually ever set foot in community. So if they got released from prison with a warrant already outstanding, that counted. But they never actually got released. Do you understand what I mean? So the report reads like they left prison, went into community, committed a new offense, and that was not the data. But it's interesting because you have to actually ask those questions because every report is usually different.
This is a great example of garbage in, garbage out, right? Which is part of and really what we want to do is equip you guys, which it seems like you already are equipped, but equip you guys even more for interrogating these scoring systems, and not assuming that they are magical predictors, right? That they're based on data that is the wrong time or the wrong type of data, or the target, they're asking the wrong question. That's almost always the case.
Target is the top thing question. That came to my mind. Is how do you equip someone to ask the right questions? Well, what are you optimizing to, and is that really the outcome that you care about? And it sounds like the answer is no here. They're just optimizing to warrants when they care about actual reoffending. And then what was the data it was trained on? Those are two of the questions at the very beginning of any audit we would do, and one of the first ways that we suggest interrogating these systems is what is the definition of success, and what's the historical data that that informs it for this model.
And this the first question is what is the definition of success? In other words, what are you optimizing to? What is the definition? What is the target that you're trying to predict? And here it is, let's say warrants. Now they've chosen warrants because they think it's a proxy for crime. But it's perfectly reasonable to say, when is that actually true? When does that tell the wrong story? For example, that tells the wrong story when the warrant predates the prison stay in the first place, right? But it's also just wrong if the warrant, you guys would know. The point is that you guys would know. And the other point is that in fact, those questions are very intelligible to non-technical people. So you guys might think of yourselves as not data scientists because you're not data scientists, you're lawyers. But you could tell that a warrant that predates like the original sentencing is not going to be a predictor of future events. Like you can see, you know what I mean? Like it's not wrong. It's actually not that complicated.
Mm-hmm.
Can I ask you guys a question though?
But you will find them using it.
What's that, Sarah?
And that's the problem. You'll find them using that. So even in not AI situations, I did first appearances in Seattle for a very long time. And that is one of the questions they consistently ask. And the prosecutor will present to say whether or not they're going to impose a high bail or let someone out is these warrants. And so it was always incumbent on the defense attorney, if a warrant was improperly issued, to go back to the court to try to fix the data, because that data would be used as a future data point against someone, because they will issue warrants for people who are in custody in another county.
Yep.
And so they didn't even willfully fail to appear. They were prevented from appearing, but that still counted as a warrant until someone else affirmatively went back and went to that court and fixed it. But that's a ton of work.
Yeah. But we are training folks to do that. We actually just did a training on it, one of our colleagues, because of this, right? They're using failure to appears. I'm going to try not to use acronyms. Sorry, guys. Failure to appears or warrants that are used to harm people in not just in the future, but in their own case, right? Whether you can get a bail that you can afford to post in the case that you have pending is dependent on this old information. And so, like you said, people who are arrested more often, police behavior, have more arrests and therefore have more opportunities maybe to be issued these data points that are not legitimate, for example. So there's just like a lot of ways that it gets compounded as well.
Is it plausible for you all to question or challenge the use of that kind of system generally versus to try and clean up data points like you're describing? Like if there's a junk warrant for this person, you got to clean it out to make sure it doesn't, follow them around and dog their scores for a long time. But is there an opportunity to more generally say, hey, this kind of tool, which is used on many, many cases, is really pointed at the wrong sort of target? Does a chance for that challenge come up in any particular case, or is there a different venue where you would raise such a challenge?
I'm going to let Sarah has an answer for you, I think.
So there's a court rule that determines what data points in any given case, mostly any point of law, you get to use. There are tests that give you X, Y, Z data point that you must meet to fulfill said test. There are rules in Washington about the data points that can be considered in the judge's discretion that allow them to impose bail, non-impose bail, impose amounts. And those rules, the legislature to some degree is responsible for it, but so are the courts. And they have many stakeholders have input. Now, me as a line defender, I absolutely can tell them that this is garbage. Are they going to ignore me? Yes, because I can tell you I've told them the data is garbage, probably in hundreds of cases, and they just continue to ignore me and poo-poo me because I'm a defense attorney and I'm supposed to tell them it's garbage. Even if, and from an intellectual point of view, it isn't garbage because you know the data is junk. You know going in that someone else didn't clean out these data points. So then you try to go back through and they're still using them against people. I mean, they've used convictions against people that didn't exist or they were never actually convicted of, but showed up in the data as saying that this person was convicted of X, so you should hold this person in custody. I mean, there's many data points, and trying to challenge it, of course we can. We're allowed to say, theoretically, within reason, whatever we want. But whether or not we'll be taken seriously is a different place. And that's where public defenders being at the table for policy work is so important. And Deidre does a lot of rules. And so knows a lot about this process. And we have a couple other people on staff who do a lot of rules. And that's why it's so important to have people who know the area involved in the process, because that's really where you get to challenge it.
I will also say just systemically, just if I could, like 10,000 foot view, that the tension, at least in Washington's legal system, is that the systems one thinking, the systems two thinking that Kahneman wrote about. This idea that if we have these tools, whether they're computerized or not, if we have a checklist, we have a bench card, we have this AI tool, air quotes, then we're not in systems one thinking. We're not using intuition on whether people should stay in or get out. Yes, there's a court rule, but we're going to say we're relying on the number of prior failures to appear at court to say whether you in the future will come to court. There's this idea that if we make it quote unquote objective, that then somehow we're making a better decision. And it's, I won't say it's an ill motive, right? Like it's coming from this place where people want fewer biased intuition driven decisions. Whether it is, like you said, though, whether the data sets they're choosing are actually telling them about the person who's standing in front of them versus the officer that arrested them in the example we've already used, that's where it gets really tricky. I mean, say.
Listen, if you don't mind, I'll suggest something that I'd like to hear your thoughts on. It's something because I've been studying this stuff for so many years. Like, on the one hand, at the very highest level, you're like, this stuff is just a mess. It's noisy data. It's answering the wrong question. The data is unreliable, like blah, 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 bad proxies. Okay, let's say you cleaned up all the data, right? Let's say all the data was perfect and you could rely on it. It was counted the right number of, a true number of failures to appear, et cetera, and warrants. Well, then you have a question of fairness because you're like, well, then it's like the data is biased because Black folks in poor neighborhoods are just more likely to be arrested, period, for a given crime. Like, just that's the way it is. Like, it's not like police are everywhere all the time. There's some places, some of the time, that's where they do their arrests. So there's a question of fairness. But then let's imagine that you made it fair. I mean, I don't even know how you would do that, but just imagine you did that. Then you still have a question of justice, which is like, should opaque algorithms, even if they're fair versus white versus black, poor versus rich, should opaque algorithms that nobody quite understands how they work be part of the judicial system, the justice system in the first place? Like, is that constitutional?
Right.
I know you had an answer for that.
And it's very difficult to imagine that a decision that's supposed to rest with the judge, in the example we're using, that the judge is now relying on a thing that person does not understand what it is, how it's working, that is somehow fair, right? It doesn't make sense. It just kind of doesn't make sense.
People always will say, quite rightly, that judges are also like biased. They're humans, and the system here is imperfect and it's just trying to help that system. But I have seen little evidence that it's actually effective in any of those three levels. Anyway, you know what? We didn't even get through one question. I
know
never mind. Two questions. You guys said
on question
15 questions or something. Here we are stuck on number one. Jake, sorry.
This is the beginning of the series of podcast episodes with these wonderful folks.
Yeah, maybe we should just do one question per episode. I don't know.
I had another thought on this. To the actual question of how do you help public defenders, ask the right questions, challenge these tools. One thing that we almost always ask in an audit is, well, what testing have you done of your tool to ensure that it works or is fair? And sometimes the answer is just a deafening silence, and that's its own answer, and if you have a chance to ask the other side, okay, so what's behind the recidivism risk score? Show us how it was calibrated and how it was tested for demographic fairness. Of course, those tests don't exist for many of these tools, and you might find that out. Or if there was testing, then you can inspect it and
Jake, sorry to interrupt, but fairness is defined as, well, we're just following the data and this is what the data says, so it's fair. You know what I mean? It's like, it's circular. There's no ground truth. There's no way for anybody to go and actually measure someone's criminality directly, objectively, right? All you have is the data. And so if the data is biased and missing, which it is, how do you prove that? Sorry.
And I will say that there are some better examples out there. I'm thinking of the NIST testing suite for facial recognition algorithms. I don't know if y'all have come across that, but when you mentioned flock cameras, I thought of that. I don't know if today's gutted version of NIST is maintaining this excellent public resource, but in the last 5 years or so, NIST, the national agency in charge of measuring stuff, got wind that like facial recognition tools,
something.
Yeah. At some point, I need that acronym.
Yeah.
They're the measurements people.
Exactly.
Standards in technology. Anyway,
that's probably what it is.
They learned that facial recognition is being used everywhere, like at TSA, in the airport. It's being used on border crossings and visa and so on. And they developed a wonderful benchmarking test to test does it work equally across genders, skin tones, ages.
Uh-huh. Right.
That was partly prompted by the wonderful work of the Gender Shades study that showed many off-the-shelf systems did not work as well for darker skin tones, older people, and women, largely because they had been missing a lot of that data in the training. So anyway, NIST created a very rigorous test, and now there was an actual leaderboard. Like if you procure this system, you'll get this accuracy by race, gender, and age. So it is possible to actually test tools like this. It does take a big effort, and NIST spent a lot of time and money developing those tests and like publishing the reports, but it's out there as a possibility if we invested in it.
Well, but let me just point out, Jake, sorry to disagree with you there, but to the earlier point, I mean, NIST facial recognition tests are great. So I'm not disagreeing with you about what you said about NIST, but it really is not the same problem, right? Because with that, like the ground truth is that they have like a gold standard of pictures where they're like, do you get this age, gender, race correct, or whatever the question is? They have the ground truth of each photograph. They know what the actual answer is. Whereas like, again, like what these recidivism risk algorithms are trying to go for is a measurement of future criminality, which there is no objective test for. So how would you know whether one thing is doing a better job than another thing? Like if you had competing recidivism risk algorithms, you know what I mean?
I do. I mean, I don't know that the tests would look anything like the NIST tests, but I guess my broader point is that if there's a sort of public-centered effort to inspect a technology tool like this, you can come up with something useful that goes deeper than the commercial claims that like, oh, our tool is just great. It works great, and they always have some snazzy evidence.
I will just emphasize what Jake started that with, which is like, are you guys allowed to request the fairness testing that these tools that are being used have already undergone? And have they undergone any tests? Like, are you allowed to inspect those results?
I'm trying to think of like the examples we've been talking about are either the release examples at the end of a sentence at parole or at the beginning of a case at bail or arraignment. And I think just each jurisdiction, defenders have the opportunity, like when the courts announce they're going to start using a tool, if they weren't involved before that, to pursue some litigation to get the information if they're not forthcoming. Now, usually, I'm not suggesting the court's not forthcoming. I think what happens is the court bought the tool from someone who claims proprietary, stake in the tool, and they may not even have it themselves. And so somebody's got to go get it from the folks who claim ownership over the tool, if that makes sense. And I've heard of people doing that if they weren't involved, with the conversations beforehand. I don't know how successful. That's like a great question. It would be something we can take back to our colleagues and see if we can't start gathering some information about how successful people are being about asking that question around fairness testing.
It's outrageous to me that they could just be like, oh, our opaque tool just scores people, but we're not going to tell you whether it works. Or why we think it works.
Or how it works.
Yeah.
Right?
How is that constitutional,
Insane.
Guys, this is where we're going to stop because we're 34 minutes in. I know, it's so frustrating.
We almost tackled one question.
Oh my goodness.
One question down, 15 to go, and a great start to a conversation that I hope we will continue soon. Thank you so much for coming, guys. Appreciate it.
Yeah, thanks for having us.
Thank you.
Just hold